Enterprise TV, a tradition of truth.
Thanks for staying with us. The Supreme Court on Tuesday dismissed an application by Emeka Ihedioha of the People's Democratic Party in Imo State, seeking to issue a certificate of return as a rightful governor of Imo State, stating as well that Governor Hope Uzodinma wasn't qualified to run in the first place. In a ruling read by Justice Tijani Abubakar on Tuesday, the Apex Court dismissed the application for lacking in merit, describing it as unnecessary and vexatious, and as such awarded the cost of 40 million naira against Mike Ozekhome for bringing the matter before the court. Those to be paid are the Action People's Party, Uche Nadi, Uche Musu, and the Independent National Electoral Commission, INEC. In the motion considered to be frivolous by the court, Ozekhome had asked the court for a consequential order to compel INEC to issue a first certificate of return to Ihedioha to enable him spend a 4-year tenure as Imo State Governor. He said that Senator Hope Uzodinma unlawfully spent the 4 years which Ihedioha ought to spend. In the motion, Ozekhome claimed that the All Progressives Congress had no candidate in the 2019 Imo governorship election. Hence, Uzodinma ought not to have been made governor on the platform of the All Progressives Congress. However, the Apex Court dismissed the motion on the ground that it had no jurisdiction to entertain such a motion. Now, and our guest for this section is a lawyer himself, and that is Barrister Tunji Abdulhamid. Barrister Tunji, welcome to Enterprise Morning.
Thank you for having me. It's my pleasure to be with you.
Thank you once again. Barrister, all matters of this kind end at the Supreme Court, and for Mr. Emeka Ihedioha, this must be a sad ending. What's your take on that?
I don't even understand what the learned senior advocate, respected one for that matter. I don't know what exactly he wants to achieve with that application. Because I've gone through the law for as far as I know, and I don't know the legal framework upon which the application was brought. I received about election petition. Is it a pre-election matter? Or what basis? And then if you see the Supreme Court can only entertain a matter that's between the state and the federal, or between the state and the state. That's when the Supreme Court can invoke its jurisdiction, original jurisdiction to entertain the matter. You cannot just as an individual just fight case and go straight to the Supreme Court. And let's even leave that one. We are talking about election here, qualification of a candidate. What are the laws? The law is that if you want to challenge qualification of a candidate, either as a pre-election matter or post-election matter, the pre-election matter by our law, you have 14 days in which to do that. By the post-election matter, you go to tribunal. These processes have been exhausted, and Supreme Court has taken decision on that. So I don't know what basis upon which the learned senior advocate, respected for that matter, is trying to do, and the basis upon which this application was brought. For me, like I said before now, it's an abuse of court process, and I agree with the Supreme Court that it's frivolous, it's vexation, and does not have any basis under our law.
Now, Ihedioha said the Supreme Court has powers to reverse it itself. Can you help us make sense of that statement?
Yes, Supreme Court has the power to reverse itself. It's the only court in Nigeria that is not bound by its own decision. We talk about binding precedent. That's what called precedent in law, and those precedents are bound. In other words, if you are a lower court, if a high court is bound by the decision of the Court of Appeal, the Court of Appeal is bound by the decision of the Supreme Court. All courts are bound by the decision of the Supreme Court. So even if you have a different position, once the Supreme Court says this, you must be bound by it. But the Supreme Court, being the highest court of the land, is the only court that is not bound by its own decision. It can review its position. Then when you say a court can review its position, it is not in the same matter. If I have a matter between you and I, and just like what happened in the Imo State now, that has been decided by the Supreme Court, if another person is filing a case similar to that, he can now say, look, I am aware of the decision between Imo State regarding audio and this and that. But this is my case. I want you to look at it again. There was an error in that case. So based on that, you can revise, you can change it. That is the field that we're talking about. It's not because it's not between the same party. When the party, the matter has been decided between two parties. You and I have been to court. Supreme Court has taken decision on that. You will now file an application against Supreme Court. Please review it. No, it will be between other parties. When those parties now brought the case before the court can now say, look, though in social case this was my stand, but on second look we realized that there was an error, and therefore we're not going to go by that decision. We are going to go this way. That is review. That's what they're talking about. It's not about him just not bringing an application. And I expect a learned senior advocate who is well respected in that matter and a very good lawyer to that to know that, look, Supreme Court will not be able to look at that. They have no jurisdiction. The only application that can be brought to court are the cases that can be started from the Supreme Court are only cases between the state and the federation, the state between states. Those are the only two cases that you can start from Supreme Court. Other cases must start from the either High Court, Court of Appeal, or even the Magistrate Court, depending on the nature of the case. So I don't know like I said, I don't know the basis upon which the law or upon which the national advocate is being brought the application before the court.
All right, but in looking at the material facts in the matter, what is your personal legal opinion of either omissions or commissions in the case?
Omission, you have to be specific. You know, if you say omission or commission, is it a categorical omission? Is it an error of
maybe it could be in the alignment, of the case, possibly in his plea.
The reality is this: even if a court gives a wrong decision, whether rightly or wrongly, that decision becomes binding, and that's the law.
Okay.
If you are not the highest court, it can be changed by the next court. But if you are the highest court, unfortunately, that stands until it is reviewed by them or changed by them. And when it's changed, it won't change your home. That is gone. The one that has been changed you will not be the beneficiary of that change. Except you have another case in the future, you can now say, okay, this and this and happen. So if there's an omission, the court has the power to. If it's about technical, we're talking about clerical error. If it's about clerical error or omission, yes, the court can amend it and change it. But if it's about the main issue, the case itself, the facts or the decision itself, that cannot be they call a mere omission. They have taken their decision, they've taken the decision, whether wrongly or rightly.
But Mr. Kinji, the court further held the motion and calculated that the design, bringing it to the court in the first place, was a mockery to the Supreme Court. How true is that assertion?
Yeah, that's exactly what I just said. That look, if you know a court has no power to hear a matter, or the court has taken decision on a matter before, and you are not bringing the matter before the court, you want the court to say a different thing. Then in other words, you want to test the court to see whether or not they know what they are doing or they don't know what they are doing. That is what they are saying. And in law, when we say a matter is an abuse of court process, what we are saying is that it's an embarrassing application or matter that is brought before the court. That's what we call abuse of court process. There are so many things we call abuse. If you file multiple of cases, it's an abuse of court process. If you file processes that are not supposed to file before the court, we call it an abuse of court processes. So the court is trying to see him as he just want to test us and try us and waste our time. And that's exactly because it's no advocate. Even with due respect, a student of law school or even university students will know that, look, they know the cases that can be started from the Supreme Court, the kind of application that can be taken to the Supreme Court. I hear that this application was filed almost 3 years ago or so. Yeah. I mean, it was not hard because some people thought it was just filed recently. Because some people are also saying that we need to correct that. It wasn't filed recently. It was filed almost 3 years ago and it was not taken by the court. For me, the Supreme Court has done the right.
But don't you think 40 million naira is too much?
It's not.
Really?
It's not.
If he doesn't pay that money, then what
we
happens?
are having frivolous cases in court because people are not being punished. Litigation. If you go to England, you file a case and you, God forbid that you do not win your case, you will regret going to court because the cost you will incur. You will even say, why? You will run into millions of naira. May, depending on the nature of the
So who's
case.
going to pay that money now? Is it Michael
It was
Ozekome's
already
client?
at him. He was asked to pay it.
So he's going to pay it from his
If his
personal
client can now
purse.
give it to him behind camera, so be it. But what the cost is that he should pay personally.
If he doesn't pay, what
The
happens?
cost, in fact, he was even lucky. If we are to be in a country where things are not done without, because I even see bias there. Imagine one junior lawyer that did that. You can even be a grant to revoke the certificate and say that this is misconduct. It can be in England that I know, there can be a grant for you to lose your certificate to practice. You dare not do that kind of a thing. Things that you know deliberately that you know that it's not even proper. As a senior lawyer for that matter, they can be a grant for you to. So he must pay. If he doesn't pay, they know how to catch him.
It's really a very dicey one there. And what else?
But if he doesn't pay, and those who are supposed to collect the money are not complaining, they did not report him to the appropriate, they did not file the proper processes to say he has not paid the money that you say he should pay us. Nobody will say anything. But if they take steps and say, look, there are an award against you, you did not pay. In fact, they can even go to court and enforce it. They can even garnish his account. Those who own the money, they can file an application to garnish it. That's a judgment of court against them. So in other words, it's owing them. And it's Supreme Court. They can file a motion to execute, to even carry his property or something or whatever, or do a garnish. They have so many process, and at Supreme Court on their own, if there's a proper application filed before the court, they can also take another decision against him for contempt.
But if I might ask, how does this stand between substantive justice and technicalities? And the reason I'm asking this is, don't you think there were grounds upon which the case would have swung the other way around?
You see, there's this thin line between what we call technicalities and the law. Technicalities, as far as I'm concerned, is part of the law. If there's no technicality in law, you won't call any lawyer a good lawyer. Everybody will be equal, will be at par. You are called a good lawyer because you can see the loophole other people will not see in that law. You are said to be to know your job very well because you can bring out a thin difference between what other people will not see. So those are the things you people call technicalities. If a law says, look, this is the way and manner things should be done, and you fail to do it, and the court say, look, in view of that, I will not entertain your case, or I will throw out your case. Can we say that is technicality? Laws are meant to be obeyed. They're not just there for the purpose of it. So if a law is made and you decide to flaunt it and say because the court will say substantial justice, there are some technicalities that are not that should not be looked into. Some of them there are some that are fundamental. That's what we call it in law. There are some are fundamental. When you say this is the way and manner you should initiate a proceeding, or this is a court you can file a case, you will now go to another court. That court now say no, you are not supposed to come here. You now told you that you now say technicality. That's not technicality. That's not technicality. So technicality is part of the law, as far as I'm concerned. But there are some technicalities that are fundamental. There are some that are not fundamental. Those are the ones the court will say will overlook. But those that are fundamental cannot be overlooked. So in fact, as little as this, let me just say, there's a Supreme Court authority. If you file a case on my behalf, as a lawyer, I file a case on your behalf. But people are saying, look, we should not be punishing litigant for the error of a lawyer. Yeah, I didn't put my name. My name is Tuji Abdulhamid. And I put my firm name is Ayo Abdulhamid Chambers. I put Ayo Abdulhamid Chambers. I didn't put Tuji Abdulhamid. I now sign. As far as that process is concerned, it's not competent, and it can be thrown out. For just on that, the court can refuse to hear your application and say they lack jurisdiction because you did not initiate your process the way and manner the law requires of you. So that is also seen as technicality by our people. Technicality is not just we can't just take it away like that. But there are some that are not fundamental. Those that are not fundamental is the one the court is saying, look, you should not bother about yourself about those things. There are some that are fundamental.
All right. For the purpose of the conversation, we could have had this judgment go another way, and we would have had lawyers saying the court is right. But like I asked you earlier, if we consider where the lawyers are coming from or the perspective the lawyers are coming from as to the court's judgment on Michael Ozekhome, do you think that this will stop the supposed quest or front running of lawyers having to file frivolous cases at the courts?
To an extent, it will deter some people from going through. If you don't have if you are not bellyful, if you are not full, if you are not buoyant, you won't risk any frivolous application before the court because you may likely get a fine that you may not be able to pay. So people will be wary of what they file before the court. So it's a kind of detriment. I've been saying it before that, look, if you go to court as a defendant, not even only as a lawyer, if you are a defendant and you decide to go to court to file a case, and you do not win that case because the case is frivolous, they should slam a heavy penalty or fine on you. Next time you think twice. Because you see some of these things that we're talking about, people blame lawyers and say the lawyer that are advising they're not advising their client properly. People like us who will tell you the truth, they see us, you don't know what you're doing. So whatever they want to hear is what they want to hear. When they are telling you and you are telling them, look, this case, you don't have a good case, but we can take a chance. Likely there might be an error from somewhere there. Some of them will tell you, no, I have a case, this is a good case. He want you to see it from the angle he is seeing it. And if you are not doing that, they will see you as somebody who doesn't even know what is doing. So they prefer those lawyers who will tell them what they want to hear. I am not such a lawyer. I don't have money, but I have my integrity. And I don't like a situation whereby I will file a case and a court will tell me, are you a lawyer? Don't you know this is not proper? That is what they are telling the SN indirectly, that you don't even know what you are doing.
You know, the same court said the same thing during the presidential tribunal for the Labour Party and the PDP, where they said that their petitions were frivolous as to the fact that they didn't have evidence to back it up. So how do you decipher a case that is frivolous and that which is properly put together before the court? Because considering from the lawyer's perspective, he feels that what he has put together is authentic, good enough with all the facts stated, and then the judge looks at it or the court looks at it and says there is no substance in this suit.
A case is frivolous if it's not properly done in terms of how it should be initiated. A case is frivolous if the ingredient that is required for you to prove your case are not available and you want to go to court. A case is frivolous if you know that, look, these things, I need these things for me to do my job, to win this case, but they are not available. Yet you still decide to say, let me just go and see whether or not I will get it. You see, sometimes law, like I always tell people, law is law. Law is not sentiment. Law is not based on anything. And law is not what most of those who are not lawyers sees as law. Law is what is law, not about sentiment, not about anything. So when the law says, sometimes it may not be correct. It may not look good in the eyes of those who are not lawyers. Okay. But as far as law is concerned, even judges sometimes they will tell you, if I have my way, I will not go this way. Unfortunately, that's the law. I've seen cases in that manner. I've attended a case whereby a judge was questioning my application before the court, but I have my stand and I know what I was doing because it looked somehow. It looked like I want to. The case is like a consent judgment. What we call consent judgment is that you and I agree that this is what we want the court to enter as judgment, and court to enter those as judgment. Thereafter, I now decided to say I was not challenging it. Thing that I voluntarily entered into. But I saw reason to challenge it. And I was trying to explain to the judge that this is the reason why this cannot stand. The most lawyers in the court that day, they were looking at me as this guy does not know what he's doing. They were even shouting me down. I stood my ground. Even the judge was questioning me. But when the judgment was to be delivered, it was delivered in my favor. The judge said, if I have my way, I will go this way. But unfortunately, Mr. Adamus was right. That was law. So that is the way it is. Sometimes the way you look at it, even lawyers, the way some lawyers look at it, some don't look at it critically, and some just follow, and then follow people, and then give their own decision. So we don't say technicality or everything is technicality. No, like that's a Ehodia case. If the court should take it now, are you expecting the court to now start the case de novo again? When I say de novo, you start it afresh and then start doing another application. You are starting the case again. Is that no end to litigation? That case has been ended since 2000 Supreme Court gave decision in that matter in 2020. Yeah. So you want them to open the case again? On what basis? Is it by application or is that the normal process to even initiate such a? If the court is to look into it, the merit of the case, is that the process through which the court should look at it? Should the court now ask them to go and file proper case before the Supreme Court and start calling witnesses again to look at the case? No, don't be done that way, because you are asking the court to reopen the case that has already been concluded. That's what you are trying to say indirectly, or you are trying the court to say, look, because it will be injustice to the what's it called? Hope to the man, His Excellency the Governor of Imo State. If that decision is taken based on application before the court, just mere affidavit. There is no evidence before the court that nobody has come to testify and say this is the way it is. It's just going to be based on affidavit of another person. It won't give a proper. So it will look injustice to those people too. Just like you people will want to see that. Why would the court not look at it? If the court was to be looking at those things in that manner, there won't be an end to litigation. Because if that application had been granted yesterday or so, I'll tell you, by this week, you'll see so many applications before the court in that manner. Asking, even the case that ended in 1988, some people will come and say, court, please review this case. That's an error.
But, Barrister Tunji, I would love for you to maybe help us clarify this and knowing where you're coming from. And if it's possible, I would love us to take a reminisce back to, just like you said, the 14th of January 2020, when the Supreme Court of Nigeria reached a unanimous decision that election results had been tampered with by the fact that hundreds of thousands of votes from a shocking 388 polling units were not included, and therefore they deposed Ihedioha and made Uzodinma the governor. And the fact on ground is, even if they collated every result for the 388 polling units and added them together, it wouldn't have matched the number of Uzodinma to have won Ihedioha. Now, I'd love you to make sense of all of this now, if we can reminisce back. Don't you think there's also some technicalities in there that was neglected in favor of Ihedioha?
You know, sometimes when we look at cases in court, and sometimes when they ask me questions regarding cases in court, I sometimes say I can't make comment on that because I don't know what is before the court. Sometimes what you read in the paper is not what is before the court. Sometimes the summary of the cases that's been produced by the reporters and not what exactly happened before the court. You have not read if you have not seen the processes tried by the parties. For you to reach a particular conclusion will be very, very dangerous and very, very misleading sometimes, because a little, like I said, the case I just explained, the one I said consent judgment, but a little slip that I lied on. In other words, the case is about somebody is owing me. He went to court. They have a term of judgment. In that term of judgment, he said he admitted, I am owing so amount of money. He ended there. There was no any other provision in that consent judgment that says he must pay that money on so day. So, and I went to court and said, no, this is a mere declaration or acceptance of old debt, which you can only, which is not itself enough to be enforced. You have to go and file another case in court for you to enforce it. That was what I relied on. I said, look, I'm not saying this consent judgment did not exist. There is consent judgment, but it is not enough. It is not right to enforce it based on this alone. You have to go back to court, file a new case, and rely on that judgment to enforce it. That was my position, and the court agreed with me. So in that situation, people will say, this judgment that says somebody is owing, you now say you cannot enforce it. But I've seen something that says that make it inchoate. It was an inchoate judgment as far as that concerned. So what I'm saying is that we cannot just sit in the studio or in our houses or whatever and look at the cases before the court, the facts before the court, the file before the court, what has been filed before the court. We are very, very germane in analyzing a case before the court. We must not rely only on a newspaper publication or whatever. But I've seen a situation whereby personally I did a case at the federal court, and the next day I was reading the same case in the newspaper. I was reading a different thing. I was reading a different thing. So sometimes it is not safe to just rely on those things. And that's why I restrain myself whenever I don't have access to those documents before the court, and they will just rely on the headline newspaper or some caption from the newspaper and say this is what the court says. So let me the case before the court in this motion was not even about the 366, how many votes that was deducted. It was about the fact that, look, this man was not qualified to contest. So, by our law, if somebody is not qualified to contest, at what stage are you supposed to challenge it? Was it not part of the case? Why did you not bring those issues out at the Supreme Court or even before at the tribunal? Why did you not say these are the issues? This is not qualified because of this. Why did you not raise those issues? Yeah, and if you raise those issues and it was decided by the court and said no, why are you bringing it back again? That's what they call res judicata.
What did you say?
Res judicata.
Okay.
And what does that mean, sorry?
That means you cannot continue to litigate the same matter. There must be an end to litigation. So,
that's Latin, right?
Yes. So what I'm saying now is that, look, there are processes to be followed. If you are contesting an election, if it's a pre-election matter, you have a time within which to challenge it. If it's a tribunal matter, you have a time within which to challenge it. So if you can't challenge it at those period, unfortunately, even if you have a good case, you've lost it. And I will consider that is technicality. If the law says I must file a case within 20 days, and I decide to wait for 3 months, and after filing people say, why can't the court look at the merit of the case? No. Then we have law, and we must go by the law. Otherwise, everybody will just be doing things the way they like. So that is the issue. So that's what people call technicalities. Law says I must do this within social time. I did not do it. The court based on that say my case is not competent. And people now say, they did not look at the merits of the case. They were only looking at the technical issue of it. It's not technicality, it's fundamental.
All right.
Because for a house to stand, there must be foundation. If you have no foundation of the house, you can't have a standing house. And they said you can't put something on nothing and expect it to stand. My fault. You will say this is my fault. So that's what we're talking about now. So if you don't have foundation, no matter how good your case is, that will be that. And I always say that, look, cases in court is not about I have a good case. Winning a case in court or losing a case in court, it's not about only I have a good case. You may have a good case and you lose your case. And that's why if you engage a lawyer that don't know what is doing or what he was doing, and you may not be able to get it. Because it's not about who's saying the truth. Sometimes in court. If you are saying the truth, the court does not know that truth. You must be able to present that truth before the court. So if you are not able to present it properly before the court will not see the truth. So it's about presentation and the law. So the fact that you have a good case is not a guarantee that you are winning your case. The fact that you have a bad case is not a guarantee that you are losing your case. And in any event, in our law, the body is on you who is alleging. In fact, the law is to the defense that, look, the defendant did not even do anything. If I've gone through your paper and I realize that nothing serious, so fundamental or serious has been put there, I don't have to. I'll just hold my hand. I'll be looking at you. I'll just do a 2 or 3 paragraph statement, and that's all.
Right.
So it's not compulsory that the defendant must even defend the case and say no. It must give, because that's what people say again. Why are they not saying anything? Why are they not saying anything about it? It's not compulsory. It's technical. And that, you see in the presidential tribunal, you can see APC just they call only one witness because they studied the case of and they realize that, look, this case will not notify. So just limit your risk, and they call one witness, and that's all. So it's not the law says you cannot rely on the witness of the defendant to win your case. You must win your case at your own instance.
Wow. You cannot rely on
the witness of the defendant's case to win your case. So you cannot say because the defendant did not bring enough evidence to challenge what you have said, therefore the court must give you. No, it's your body. You must take it. And that's what people are relying on now. And that's why you see the Imo state election, the Kogi election, or whatever. People now realize that, look, I don't have to even keep people. I just let me go and write a result, and then it's their body to go and prove it before the court that it was not correct. So it's your body. If you go to court, you have to prove it, not me. And the fact that people see it on the TV and we saw it on this and that does not matter. The court, what is before the court is what the court rely on, not what they see outside the court.
And that's just about the time we have on Enterprise Morning on our conversation today. And many thanks to you, Mr. Tunji Abdul Hamid, for being part of our show and always making our time to be part of this program. Thank you so very much.
Thank you, Tunji.
Thank you, Barrister.
I also
Thank
have
you.
my co-host with me, Esther.
Yes.
Thank you always. for this being part of the show. I am Henry Ikwibike. I'll see you next time. Bye-bye.
Enterprise TV, your one-stop shop for news, programs, human angle stories, the economy, sports, and much more. We go the extra mile to bring incredible details to you. So hop on the train now. Enterprise TV, a tradition.